Okay, so good morning, everybody, to today's presentation. Just a couple of housekeeping items as we go. If you don't mind putting yourselves on mute while the presentation is going on, then feel free to unmute yourself, ask any questions that you have, or if you want to use a text chat, you can do that and I'll watch out for those questions. Just as a reminder that at 12:15 today, we'll be having the startup expansion webinar for the WEOC loan. So if anybody's interested in that, you could send me a chat if you need the link for that, and I could put that in there too. And just as a reminder, they're going forward to the end of June for sure at 12:15. So without any further ado, I will just get to here. So I just wanted to welcome back for the final part of our boot camp for scaling up. Shokouh Abadi. She's a barrister and solicitor in Ontario. She's the founder of KMEG Law and TEDx speaker. She has extensive experience in business law, international commercial law, regulatory compliance, anti-money laundering, and has taught various courses of law, including business law and contract law at different universities in England and Iran. She holds a Ph.D. and an LLM, Masters of Law in International Business Law. So we welcome you back and really thankful that you were put this boot camp on for us.
Thank you. Thank you so much, Lori. Hello, everyone. I'm going to share my screen and the slides here. So good to see you all again. And this is, as Lori said, this is the final session of our business law bootcamp for scaling up businesses and the growth stage. Before we start this session, I would like to remind that, again, this presentation is just for educational purposes. And if you have any particular question or specific legal matter, please seek legal counsel, because I'm going to explain general principles of law. And it's good to consult with a lawyer for any specific matter. This session, we will cover some general topics related to hiring employees. As you can see, our agenda for today is explaining the difference between employees and independent contractors, employment contracts, the general terms and conditions that are usually included in an employment contract, different forms of employment or independent contractors contracts, agreements that could be indefinite or fixed term. Also employees' obligations and employers' obligations, and finally, different ways of terminating an employment contract. The first thing that usually is discussed in employment law is the difference between an employee and an independent contractor. These are two different concepts with different legal results. So it's really good to know the difference between an employee and an independent contractor, because whenever you want to hire somebody for some services, as an employer, you have some obligations. And depending on the type of contract, your obligations could be different. If you hire an employee, that employee works for you. So that employee is in the business of the employer. An independent contractor is in business on their own account. So the difference is that an employee works for the employer and is in the business of the employer. Whereas an independent contractor works for the employer, but he or she has his own business and works on their own account. It really doesn't matter what the title of the contract is, even if you call it an employment contract, but the nature of the relationship is closer to an independent contractor contract agreement. If there's any dispute, the court will decide based on those factors, whether the relationship is an employment relationship or an independent contractor relationship. And there are some factors that the courts consider in making the decision and differentiating between an employee and independent contractor. As you can see, these are the bullet points are the main factors that you need to consider in making a decision whether your relationship with the other party is an employment or an independent contractor relationship. The first one is a control. Whether the employer has control over the employee and his work, or, as the name indicates, that person is independent and the employer has less control. So whenever the employer has control over the services of that person, the relationship is an employment contract. An independent contractor is not controlled fully by the employer. They have their own business. They work for the employer for a specific term or on a specific project, but there is no such control over independent contractors. Whereas employees are under full control of the employer, and they have to abide by and comply with the policies, procedures of the employer. Another factor that must be considered in distinguishing between an employee and an independent contractor is working for one or more companies. An employee works for one company. An employee is hired by one person, that individual or company. An independent contractor is independent, and they are free to work for as many companies as they want. They are not restricted and limited to work for one employer. The other factor that must be considered in distinguishing between an employee and an independent contractor is the ownership of tools and equipment. In an employment relationship, the employee, normally, they don't bring any tools or equipment. All the tools and equipment are provided by the employer. Whereas in an independent contractor relationship, the independent contractor brings the tools and equipment to perform those services. So the ownership of tools and equipment can be an indicator in determining the type of relationship between an employer and an employee or independent contractor. The other factor is using the help of others. Those persons could be assistants, helpers, subcontractors. In an employment relationship, employees do not usually have their own subcontractors or their own helpers and assistants. They work for the employer and benefit and use the services and facilities that are available in that workplace. Whereas an independent contractor can have assistants, their own helpers, and may subcontract with other subcontractors. So they have this freedom of having helpers and assistants. Another factor is financial risk, which determines the liability. An employee, once is employed by an employer, they don't have any, they don't face any financial risk. They are hired. They are on the safe side. They work for the employer, and they don't have any liability apart from their employment relationship. Whereas an independent contractor accepts any financial risk that may occur in their relationship with the employer. They have liability. Anything that may happen, they are liable for that. That's also related to investment and management. In an employment relationship, in an employment contract, the employer makes any type of investment that is required, and the employer manages everything. The employee just performs the duties and obligations that are defined in the contract. Whereas in an independent contract relationship, the independent contractor manages and makes investments in that project. So that's why they have to accept the risk, liabilities, and even profit, which is the final factor. So because there is this financial risk, investment and management, there is also this opportunity to profit, to make profit out of that relationship for independent contractors. Whereas employees do not have that opportunity. They just get their compensation, whatever it is defined in the contract, in the employment contract with the employer. The opportunity to profit is very limited for employees. So these are the main factors, and this is not an exhaustive list. There are other factors. Whenever there is any dispute, the court will determine whether the relationship is an employment or an independent contractor relationship. But these are the main and general factors that usually are considered in distinguishing and determining the type of relationship. Does anybody have any question? Yes, Elizabeth?
Could you elaborate on the opportunity to profit, please?
Sure. Because independent contractors have the opportunity or that they can invest by having a contract with an employer. They invest. Let's say they are a consultant, or there is a development or construction company. They hire another company as an independent contractor to provide, let's say, doors or windows for that construction project. That independent contractor, the second company, the company that provides doors or windows, they make an investment. They can benefit from that investment, and they may also lose. They may face losses if, let's say, the price of doors and windows drops, and they had purchased with a higher price, and they use those equipments or products with higher price. They may lose profit. On the other hand, they may also make profit. They have the opportunity by investing in that project. They may earn more money by buying cheaper products with lower amount and selling to the main contractor or the employer by selling them and installing in that let's say condominium or that for that project. They earn money, they have the opportunity to get benefit and profit out of that investment. That's how it's exactly like running a large-scale project. There are different subcontractors. You can imagine, like for as I said, for doors, windows, elevators. There are different companies that they get involved in building that, let's say, complex or condominiums. They are each independent contractors. They invest in that project and they have the opportunity to get profit and benefit out of that investment. Whereas employees, they don't have this opportunity. They just get salaries at the end of the month with some bonus, and the opportunity to profit is very limited. Is that clear?
Yeah, yeah. I just have so many small business owners who have consultants.
Yes.
And they have a contract that they think protects them, but then when the contractor jumps and goes to a competitor, they say, well, that was in their contract, you know, that they wouldn't do that, that they had a non-compete clause in their contract.
We're going to discuss that later. Yes.
Oh, good. Okay. I'm interested in that for a specific client.
Sure. I'm going to discuss that non-compete, non-solicitation, and non-disclosure clauses. But these are the main factors that must be considered in distinguishing different types of contracts between an employer, an employee, and independent contractor. Okay, next slide is employment contracts are legally binding. If you could recall from our first session, we discussed the difference between agreements and contracts. Agreements can be, some agreements are binding, legally enforceable, and some of them are not, such as letters of intent. We said these are just agreements which are not legally binding, whereas contracts are legally binding. Employment contracts, once signed by the parties, are legally binding. And these contracts can have different terms and conditions. These are some of those terms and conditions that are usually covered in an employment contract. An employment contract can have clauses related to the job, the description of the job, what is the position of the employee, the responsibilities of the employee, probationary period, which is usually 3 months, but can be more, compensation, which is the salary and everything, like anything that must be paid to the employee for the services they provide to the employer. The hours of work, vacation, non-solicitation, non-competition, and confidentiality clauses, workplace policies and procedures, and termination clause. Not all employment contracts have all these terms and conditions, but these are some of the most important provisions that must be somehow included in the employment contract. Employment contracts and also independent contract agreements can be indefinite or fixed term. Indefinite is clear, so it's self-explanatory. So it's for an indefinite period of time. But fixed term contracts are usually either for a specific time frame let's say if it's just 1 year or 6 months, or for a specific project or task. Usually, fixed-term contracts are independent contract agreements. But again, it really depends on all of those factors that we discussed in our first slide. And usually, again, indefinite contracts are employment contracts. But again, all those factors must be considered before making any decision. Employees and employers have some obligations because, as we said, an employment contract is legally binding. It's a contract. There are at least two parties, two sides. Each have obligations towards the other. Some of the main obligations of the employee are these ones, as you can see on the bullet points. Some of them are implied obligations, such as attending the work, complying with the procedures and policies of the workplace, being competent in the services that they provide, duty of good faith, and being honest at work, which can cover some duties such as confidentiality, duty not to compete, not to take secrets of the employer, duty to provide notice of resignation. If they want to resign, they have to give notice for a reasonable time, and their obligations may even continue after termination of employment contract, post-employment. Some duties such as non-compete or non-solicitation, these are some obligations that can continue several years after termination of employment contract. There are, in most employment contracts, there are some clauses which are called restrictive covenants. These restrictive covenants, mostly they are non-competition, non-solicitation, and non-disclosure clauses, can be either just one clause in the main employment contract, or they can sometimes even be a separate contract called non-competition contract or non-solicitation contract or non-disclosure and confidentiality contract. It really depends on the scope of these clauses. If they are limited and short, they can be just a clause in the main employment contract. If they are too detailed, they sometimes are, as I said, a separate contract, parallel to the main employment contract. These, as I said, these clauses are, these provisions are restrictive covenants. It means that these provisions limit employees' ability to, one, compete, and this is related to non-competition clauses or contracts. They can limit employees' ability to take other employees or clients of the employer. These are called non-solicitation clauses or contracts. And they may limit employees' ability to disclose confidential information of the employer. These are called non-disclosure or confidentiality clauses or contracts. And these provisions can be for the term of the employment while the employee is working and is employed by the employer, or for, as I said, for several years after termination of the employment contract. That may continue. there are some non-competition clauses that last for 5 years after termination of the contract. They are the employees are limited in terms of providing this similar or the same kind of services that their previous employer is providing. So once an employee terminates the contract, the employment contract with the employer, they may be bound by these clauses, especially like non-competition, let's say in terms of competition. They are bound to, in terms of working in other companies or for themselves, like setting up a business that provides similar services or products than their previous employer. So it's very important to, as an employee, to review these clauses, because even after termination, they may be bound by some clauses that they had signed with their previous employer. And for the employers to draft or review clauses that they want to restrict their employees in terms of competition, or they want to protect the work environment and their other employees. Sometimes an employee may resign and take other employees, their colleagues or their friends, out of that company, and they may start a new business very similar to the employer's business. And if there is no non-competition, non-solicitation clause, then the company may face serious problems, because they may lose their talents, their employees, and even the trade secrets and their business by just one employee that resigns and starts a new business similar to their business. So these clauses are very important, both for employers and employees. And as I said, they can be just one clause in the main employment contract, or separate contracts, very detailed contract. Employers' obligations are, of course, more detailed than employees because of this most of the time unbalanced bargaining power. Employers are considered to be more powerful than employees. So the law has more detailed provisions in terms of employers' obligations. There are two sets of obligations for employers. The first set are implied obligations, or what we call it in law, common law obligations. These are not defined in any particular act or statute, but they are legal obligations. Duty to provide work and pay for work. This is one of the most important obligations of an employer. Duty to provide a safe work environment. Duty to provide notice of termination, and I will explain this when there is an obligation to provide notice at common law, and a duty to provide notice under the Standards Act, Employment Standards Act. And duty of good faith and the ethical principles that an employer must comply with respect to their employees. The other set of employers' obligations are those obligations that are defined in the Employment Standards Act. This is one of the most important statutes, acts related to employment relationship between an employer and an employee. some of the obligations based on the ESA or Employment Standards Act are payment of wages, hours of work, overtime pay, minimum wage, public holidays, vacation with pay, equal pay for equal work, leaves of absence, and termination and severance of employment. When Employment Standards Act is applicable to an employment contract, the provisions of this act are minimum standards. In other words, the provisions must be complied with by the employer and employee, but there might be higher standards in an agreement. These are the minimum standards. Let's say for minimum wage, when the Employment Standards Act is applicable to an employment contract, an employer cannot pay less than the minimum wage that is defined by the law. They can pay higher than that. It's up to them. But that's the minimum. Again, and with respect to hours of work, there is a minimum. The parties can agree, but these are the minimum standards. And they cannot change the terms of a contract that is against the employee. It's most of the time in favor of the employee. And that's why employers must always be careful when they want to change the terms of the contract that is standard and based on Employment Standard Act, and try to keep that minimum, because if they fail, they are in breach of their obligations under the Act. The final topic that I would like to address here is termination of an employment contract or an employment relationship. An employment relationship can be terminated through different ways. By dismissal, which is done by the employer, or resignation, which is done by the employee. Dismissal can be without cause, with cause, or constructive. The first three are done by the employer, and the last one, the resignation, is made by the employee. I'm going to start with dismissal without cause, terminating an employment relationship but without cause. Dismissal without cause is either with notice or with compensation in lieu of notice. So an employer cannot dismiss, cannot terminate an employment contract without cause unless they give either a notice to the employee or they pay compensation for that period that they should have given that notice. So they have to compensate the employee for that period and then dismiss them instantly. Without that compensation, they cannot. They have to give a notice when there is no cause to terminate the contract. And what's that notice? Like, what's the definition of a notice? What's the term or the period that the employer must consider as a legal notice? If there is an enforceable termination clause in an employment contract, then the Employment Standards Act is applicable to the employment contractual relationship between the employee and the employer. In that case, the law defines that the period of that notice. So again, when there is an enforceable termination clause, the statute, the Employment Standards Act, is applicable, and the act defines the term of the notice. And as you can see, based on the Employment Standards Act, if the employee is hired, has been working for 3 months or more, the notice, the period of that notice should be at least 1 week. Less than 3 months, it is considered as a probationary employment, and there is no need to give any notice. For 3 months or more, 1 week minimum, 1 week notice is required. For 1 year, less than 1 year, 2 weeks. For 1 to 3 years, an additional week of notice for each additional year of employment, but there's a cap for that. Maximum of 8 weeks. This is something that is defined in the law, and the employers must comply with these regulations. If the contract, the employment contract, is under the Employment Standards Act. In other words, if there is a contract and there is an enforceable termination clause. If there is no employment contract, or there is an employment contract, but that contract does not have a termination clause, or if there is a termination clause, but the clause is very ambiguous and it's not a legal, enforceable clause, in that case, it is said that the contract is governed by the common law and not the act. So those 3 months, 1 week, 2 weeks are not applicable, and the employer must give reasonable notice. Courts have different factors in considering what reasonable notice is. It really depends on the age of the employee, the market. So the employer must consider different factors and consider that how long a reasonable employee would need to find another job. And that is considered usually based on the age and the market and different scenarios, different factors. That is considered a reasonable notice. So far, a notice is either defined by the act, it's either from 1 week to 8 weeks, or if the Employment Standards Act is not applicable, then the employer must give reasonable notice, which can be anytime between 1 week to even sometimes there are some cases up to 24 months notice was determined by the court. So it really varies on a case-by-case basis. And the parties can also agree on the duration and term of the notice in their contract. But again, they must consider the minimum that is defined in the law, as we said. They can agree, but must be more than what is defined in the law. That is minimum. They can, let's say, they can define a 2 months notice but that should be the minimum, which is defined in the law. So the parties can also define the notice period, considering the limitations of the law and applicable regulations. As I said, probationary and fixed-term employments, in probationary and fixed-term employments, there is no need to give any notice. So in the probationary period, less than 3 months, the employer has the right to dismiss the employee without any notice when they want to dismiss the employee without cause. So this is the first type of dismissal or termination of an employment contract, which is without cause. The employer just wants to dismiss the employee and there's no cause. The other scenario is when there is a cause, and that is called just cause. When there is a misconduct, dishonesty, violence, or breach of contract by the employee, the employer has the right to dismiss the employee because there is a just cause. And there is no need to give any notice to the employee because there is a cause, but the employer has the duty to warn as soon as the employer finds out about the misconduct or any signs of dishonesty. The employer has the duty to mitigate or warn the employee, but there is no need to give any notice, and the employer can dismiss the employee without any notice. The third type of termination of an employment contract by an employer is called constructive dismissal. And there are two scenarios under this type of dismissal. One is when there is a substantial unilateral change of employment terms by the employer. Let's say the employer unilaterally changes the salary or benefits or the position, changes the position of the employee, like downgrading the employee. Or the employer's conduct may indicate that the employer doesn't really want to continue the contractual relationship with the employee. For example, let's say the employer or the manager, the boss doesn't invite the employee to the meetings that he used to invite him to some of the essential meetings. They stopped inviting them and asking them to attend to some important meetings, or they stop giving them projects to work on. These conducts may indicate that the employer no longer wants to be bound by the employment contract, and they don't want to continue the contractual relationship with the employee. That is called constructive dismissal and may lead to resignation by the employee, which is the fourth type of termination of a contract, of an employment contract. An employee can end a contractual relationship with the employer by giving a clear and unequivocal resignation. And what does that mean? It means that it is the obligation and the burden is on the employer to prove that the resignation is clear and unequivocal. The employer must make sure that the employee has full intention, is willing to quit the job, and it's not under pressure or under any kind of influence to terminate the employment contract. And that is called clear and unequivocal resignation. If there is any signs that the employee is not willing or is under pressure, or the letter is not very clear that the employee wants to quit the job, that is the employer has to make that judgment, and that is not considered as a resignation. So the resignation must be clear and unequivocal, and the employer must make sure that that letter or that notice is a valid resignation. And that's how an employment contract can be terminated by an employee. Because an employment contract is a contract, it is made by mutual intention and consent of the parties. This contract can also be terminated by mutual consent of the parties. So the fifth, I would say, way of terminating an employment contract is by mutual agreement of the parties. The first three were by the first three terminations are by the employer. The fourth one, resignation, is by the employee. And as I said, they can, because employment contract is a contract, the parties can always terminate a contract by mutual consent. That's all I've got today for employment contracts, hiring employees. There are, of course, many other subjects and concepts related to employment law, which, because of the limitation of time, I didn't mention, but it's employment law and employment contracts are very important, especially for those businesses that are in the scale-up stage and they want to hire somebody for some services. And it is highly recommended that business owners pay attention and spend time in drafting, reviewing their employment contracts, because it's very, very important for their business. Thank you.
Thank you so much for that. That was great. A lot of information there. Does anybody have any questions? There was nothing in the chat, but I don't know if anybody else has any questions. Sandra said, fantastic info. Thank you very much.
You're welcome. My pleasure.
Okay, well, I don't see any hands up or anything. Oh yeah, Elizabeth, go ahead.
I guess I'll just ask again, like maybe I kind of missed it, but if a contractor comes to work for a company and they sign a contract that says has a non-compete in it, and they leave and go to a competitor, what are the options? Like, can you ask that of a contractor?
It really depends. Some non-compete clauses are not really enforceable. It really depends on the terms of the contract and the provisions of non-solicitation or non-competition clause. There are many, I know there are many non-competition clauses that are not enforceable. Even if they go to the court may consider that this is not really a valid and legal non-competition clause, because it's too much to ask from an independent contractor or an employee. So it really depends on the terms and the different facts related to that particular case. If it's a valid and applicable and enforceable non-competition clause, yes, it's possible to go after the independent contractor and seek damages or ask for damages. But I know there are some clauses that are not enforceable because, let's say, some non-competition clauses are they are against Competition Act. They want to get the monopoly of that market or that industry. Those are not enforceable. Those are invalid non-competition.
Can you repeat that again?
Some non-competition clauses are against Competition Act. Competition Act is an act that facilitates competition in the market because it is essential for the country and for the business. Some non-competition clauses try to limit the scope of services in one industry and gives monopoly to one company. Those non-competition clauses are not enforceable.
Okay, perfect. Thank you.
Those are illegal. So it really depends. I cannot give you an exact answer. It really depends on the terms of the clause and the facts. There are some enforceable and valid non-competition clauses. It is possible to go after the independent contractor or the employee and sue them, and stop them from competing with the employer. And there are some clauses that are not valid and legal.
Thank you very much.
You're welcome.
Okay, great, thank you. I'm just gonna check the chat here. Oh, yeah, and Tanya says this has been great, so thank you very much. So we really appreciate you coming in and talking to this all this information to us on, you know, scaling up our businesses and stuff like that. We were talking earlier before, and maybe we will have, or not maybe, we will have her back to do a startup boot camp. So we look forward to doing that in the fall. And if you have any questions, maybe later on or something like that, Shokouh has put her contact information there. And yeah, so I just want to say thanks again. Thanks everybody for joining us, and hope you have a great rest of the day.
Thank you, my pleasure. And feel free to reach out if you have any questions.
Sounds good. Thank you.
Have a great day. Bye-bye.
Okay, bye, everybody.